Happy Monday, everybody. Hope you're having a great Christmas season. We are just storming right along through December, and I really hope you're having a good season. We're going to be talking about estate planning and tax problem resolution today. That's always that's the topic du jour. So hopefully hope you had a good weekend, ready to talk about a little bit, some heavy topics, which we've got coming up really quickly here on The Word on Wealth. I am a California attorney, and I've been practicing, I'm trying to be a good California attorney. I've been doing it for 33 years. I got Rich Mathurin coming on at the half hour. We're going to be talking about tax problem solving at that time. What I want to do for you is I'm going to ask some questions. There are questions that get submitted to estate planning attorneys on the internet. And then I'm in an organization that lets me answer those type of questions for people. So that's good, because that means I can use any of them on the radio that I feel like. And it's not really disclosing anything. And what it's doing is it helps, it helps you listeners realize that you're not alone when it comes to having trouble understanding estate planning because of just the nature of it. Some of it just doesn't make a lot of sense. And like in today's world, you kind of think like, well, that doesn't make a lot of sense. In fact, the one question was, or two questions. One was, can I do a video will? And then another question was, can I have my will signed electronically? And that it makes sense, right? We are in 2022, almost 2023, and you think that would be a great idea. Well, in the state of California, estate planning, wills and trusts and power of attorneys, that's all controlled by California law. And California law is very specific. It's been developed over hundreds of years. And when you develop something over, the last 200 plus years, it's really hard to change it because it's kind of eked along and changed. And it's been created in ways that the courts have tested, and there's been cases and trials and appeals and all that. And the laws get shaped that way. It's not like there's a bunch of really smart people that sit around a table and say, hey, this is the best way to do it. That's kind of the way it starts. And then it gets tested by judges and by juries and all that kind of thing. So on doing a video will, okay, a video will, it helps. Anything helps to show what your will is, like your desires, like after I'm dead, I want you to do this. And that's fine. With a will, what we're trying to do is determine capacity. So when you have a regular will written out, like we all do in the state of California, you have a will and it says, basically, I, Gary Quackenbush, declare this to be my last will and testament. I identify myself, I identify my family, I say what's going to happen with my property, I identify the person that's going to be in charge after I pass away, and then I get it signed. I sign it, and what? I have two competent witnesses that are over 18, and they sign under penalty of perjury, which is like testimony, sealed, as they sign it, saying, I declare under the penalty of perjury that we became acquainted with Gary Quackenbush, and that he appeared to be of sound mind, and that he's signing this document without coercion or duress or undue influence. So if there's somebody else in the room that's got my hand, on the pencil and moving it, then that's not under my own power. It's not under necessarily my own volition, my own will. And if I can't tell the people what's going on, and these two witnesses kind of like go, whoa, does not understand what's going on, they're not going to sign the will. So the presumption is that the people that are signing the will under penalty of perjury, they're witnesses, they're not in the will, they're not related. It's not the guy's kids who have, convinced him to give, all their estate to, the two of the kids, not the other three. It's not that. So we try to get disinterested witnesses. And we've lately, the newer thing in the state of California is that the will is signed under penalty of perjury, which penalty of perjury means you're signing it under, it's basically saying under oath, this is true and correct. And if you are lying, then you can go to jail for that. So it makes it a little bit stronger of a witness. Used to be that we would get, we'd have 3 witnesses at least of a will, because when a person died, we had to go find the witnesses and have them sign a document that says, oh yeah, that's my signature. I remember signing that. And whatever I signed back then, it's still true. And then they sign this declaration that gets filed with the probate court. So as far as like doing an oral will, there's no witness to it. There's nobody there signing under the penalty of perjury, determining capacity. We don't know whether the video has been pieced together or whether it was practiced, 65 times. And then finally they got it right. And then that's what we now have is this last declaration, because mom has finally been, convinced into saying the things that you think, can you determine capacity from a video? Not, it can help. So when I am doing a video involving a will, declaring your testimony, that this is your last will, I would be doing, first of all, I'm not going to do just a will. I'm not going to go through the trouble. I'm going to do a trust for you. But if I am going to use a video, it's because I want to show that you are saying, hey, this piece of paper I just signed, this is my will, and this is what I want. This is my trust, and this is what I want. And I will ask questions of the person, and I'll do an interview for sometimes 10, 20, 30 minutes asking questions. Hey, tell us, do you have any real property? Do you have any personal property? Who are your grandkids? Who's the president of the United States? What's going on in your life? And we do this interview to determine capacity, and we do it on video. That's the kind of video stuff you can use, but doing a video will, and that's all you have. It's, if it's anytime the testament, the will, the video, anything that you're doing that's trying to show what you want to have done, the closer that follows the default, then it's easy to do. In other words, if for me, if I did a video will that said, hi, I'm Gary, and when I die, I want all of my property to go to my wife, Cheryl, and that's all I leave. Well, that happens without my will. Because we have all community property. So that would happen without my will. So if I'm doing this will, then it's no harm, no foul. I did the will, whatever. It still goes through probate if it needed to, but with a spousal transfer, it's probably not going to. So if the will is, this person saying, I'm leaving all my property to all of my children in equal shares, and I want them to be good people for the rest of their lives. I mean, that's going to happen whether you actually did that declaration or not, and it's still going to go through probate. If you're doing tricky things like I want, my son to receive $5,000 per month, and I want my daughter to only receive the car if she's getting good grades in school, that kind of stuff, there's no way that's going to work in a video. No way. It's just not going to work because that's trust language. That's language saying after I'm dead, I want these things to happen over this period of time. A will is when I die, do this. A trust is when I die, continuing doing what I've had you do, and now I want you to change and give money to this person and hold money and control money. So video will, don't think you're going to get away with the video will. If you're doing it kind of to enhance your testimony, that works, but you still have to have the documents properly prepared. I mean, don't make it even worse, and I've seen video wills that were just a really, really big problem. The next thing I wanted, the questions were, who should keep the original of my trust? And then what happens if there's a question on joint title? And those are a couple of things I want to address coming up next here on The Word of Wealth. This is Gary Quackenbush. If you want to get a hold of me, it's 855-500-TRUST. I can help you with all this kind of stuff and answer your questions, 855-500-TRUST.
You don't need to know everything.
I can tell you wanted to keep talking, and then you're like, no, I need to hit the post.
Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST. You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, our listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there, filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
This broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
Hey, good to have you along here on The Word on Wealth. This is Gary Quackenbush. We are discussing some questions that were submitted, asking some really interesting questions about estate planning to kind of help us see that this stuff is just, it seems really clear, but it's not always. All right. So the next question is about titles and deeds. And this is it's a gal that submitted it. She says, I live in California. My sister lives in Virginia. We both own condos. So one in Virginia, one in California. Neither are married. They don't plan to get married, and they neither of them have children, but they own a house in Hawaii together, and they're together on the deed. Her comment was, we own a house in Hawaii. It's in both of our names. So I think that makes it real estate. ? Can we create a living trust in California to put all three properties in it? Okay, so you get the question. It's two sisters want to know, one lives in California, one lives in Virginia. Can they together create a living trust in California and include the Virginia property, the California property, and then the Hawaii property that's in both of their names? The short answer is no. And the reasons are as follows. One is unmarried individuals don't do living trusts together. Therefore, if you're married, you would do it, that would be the opportunity to do a joint trust. But if you're not, that means your title to these properties are going to be in your individual name. So California sister has a California property and Virginia sister has a Virginia property. Each of those sisters should have their own trust. Why is that? Well, because property rights are determined by the state where the dirt is. The California property is going to be controlled by California law. The Virginia property by Virginia law. I don't know how Virginia law transfers property. I do know how it works in California. Hawaii, their laws are very different also. It's a very different, I almost said country because they act like they are a different country in a lot of ways. So the Hawaii property is going to be controlled by Hawaii law. Does that mean they need to have a Hawaii trust and a Virginia trust and a California trust? Well, that's one way to do it. The other way is that sister in California does a California trust. And in that California trust, she names her interest in the Hawaii property. So the deed, I'm assuming it's a joint deed, and whether it has right of survivorship or not is not really relevant when you have your own trust. So California sister sets up a California trust. She transfers her California property into her California trust and her half interest in the Hawaii property to her California trust. The Virginia sister does basically the same thing. I don't know how property is transferred in Virginia. I don't know whether they need legal, trusts in Virginia to transfer property. I would imagine in most places anywhere in the United States, you can use a trust to transfer property. With the reasons for the trust in Virginia are probably different than they are in California. California, we're trying to avoid probate. We're trying to make transfers better and more efficient. Virginia, maybe it's the same. I don't know. I'm a California attorney, not Virginia. So what the Virginia sister would do is whatever the estate plan laws in Virginia want her to do. And let's just assume she would set up a Virginia trust, and the Virginia trust would have her house and her one half of the Hawaii property in it. So it's going to be two separate trusts. What happens in California then? Does California actually control the Hawaii property? No. What the California trust does is it gives authority to the successor trustee that is named by the California sister. It gives that successor trustee the authority to basically go to Hawaii with like this, document called a trust. And they say, hey, I'm in charge of this property now because the person that created this trust is dead. And here's my document proving that I have authority. What needs to happen in Hawaii to transfer that property? And Hawaii has their certain laws. Now, that may require that the successor trustee retain an attorney in Hawaii to do the transfer. It may be that there's some company that can do it, but it's going to be controlled by Hawaii law. So what I've seen then is the California trustee contacts Hawaii, says, I want to transfer this property. We get information there. Sometimes we'll hire a lawyer depending on the complexity. And in Hawaii, they do the transfer per the terms of the California trust. Because the California trust says, when I die, give it to my brother. Well, then Hawaii is just using the same thing, just that we have to go through a different legal process. We can use the trust in California to instruct Hawaii on what we want done with the property, but legally we have to follow the legal protocols in Hawaii. Okay. And I'm assuming it's going to be the same in Virginia. Okay. So those are good questions. You can see that what's happening is you can put a partial interest of property into a living trust. Even if you have, like a person I talked to recently, it was a mom and two daughters, and it was like 50% for the mom and 25% for each of the daughters. Well, the daughters each had their own family and their own trust. So they would just transfer their 25% interest into their trust. That way, when they die, if the 25% interest went to their kids, well, now mom and sister and these two kids, which would be grandchildren or nieces, they would be part owners of that property too. Whether they wanted to keep it that way or not, that could be changed by agreement later. But what you're doing is you're just transferring your interest in property. So if you own half a piece of property, you put that half a piece of property into the trust. So you can do that. You can split it up. It doesn't have to be 100% of it. Okay. So those are really, really good questions. And then the other one was a question about, a deed saying it doesn't say joint tenancy or tenants in common on my and my sister's shared property. Okay, so I'm going to make some assumptions. This is going to be a California property. Two sisters own the property, and it doesn't say joint tenancy, or tenants in common. It doesn't say either one. And then the question is, does that mean that I can give my share to my kids when I pass away, since there is no survivorship? Okay, so clearly the person asking the question, and we don't know if this is a guy or a girl, this person has a sister. So the person asking the question notices that the deed doesn't say right of survivorship. So what you do then is, under California law, we're going to go back and look at what the law does by default. By default, the law says that if you take, if more than one person, so in this case, two, the asking person and sister, they take the same interest in the property. It's an undivided interest. In other words, they're both saying, we get this property together, and it's going to say sister one and sister two, that they're the owners of the property. I don't know why the deed wouldn't say at least joint tenancy or tenants in common. It could be said something, but I would imagine the deed would at least say joint tenants. Okay. Her question then has to do with, it doesn't say right of survivorship. Well, joint tenancy by default has right of survivorship. So the presumption is, if they both got the same interest in the property at the same time, that it's considered a joint tenancy with right of survivorship. Okay. If they got it at separate times, in other words, if dad gave half to one daughter, and then, and even the very next day with another deed gave the other half to the other daughter, then they're going to have acquired an interest, the same interest, but at different times. So it's not on the same deed. Okay. Makes sense. So joint tenancy by default, joint tenancy has the right of survivorship. And in the case that we're talking about, these two, a person that's asking and a sister, if you don't want to have your property go to your sister when you die, you need to hold it in tenants in common, because tenants in common lets your share pass down to your children. If you have a trust, you would take your tenants in common share and you would transfer it to your trust, so that now your half is in your trust. And when you die, it's going to go down to your children or to wherever you want it to go. And your sister is going to be dealing with her half. Okay. So joint tenancy, those are really good questions. And it's something that if you have a question about this, if you have a deed that's driving you crazy because you don't really, is it really making a lot of sense to you? Then, call me. Let's talk about it. 855-500-TRUST. This is the kind of stuff we can sort through. Sometimes we have to ask for a bunch of documents or do research, but we can figure it out and advise you on the best way. And this stuff has to be done before something happens to you, because if you're incapacitated, you can't do anything about it. And even if somebody looked at it and went, oh, wow, this is really messed up, this is going to cause problems when you die. Well, if you're not competent anymore, you can't make any decisions, then, it's not going to work. You're not going to be able to make the change. So there you go. All right. The next question is going to be, who should keep the original copy of my trust? Okay. That would be the original, would have the original wet ink signatures on it. It would have the original notary stamp on it. Who should keep them? And she goes on. Why do I assume it's a she? And it will say it's a she. I am 83 years old. My trustee lives 2 hours away. Should I send him the original or a copy? He is 51. All right. If you trust him and you know that he's going to do a good job for you, then yeah, send him a copy of the trust. You should retain the original. I don't want the originals going out to somebody else. I mean, if you're going to store the original, what you want to do is keep it in a box so it won't burn up, like a firebox, one of those little fire safe things. They're cheap. And that way, at least it has a chance of surviving a fire for a couple of hours. Some people put them in a safe deposit box. I'm not a super big fan of that, because I hear a lot of people having problems with that. You pass away, they're trying to get to your will, trying to get to your trust. They're not sure who's the one that's in charge. So if you put it away and didn't tell anybody who's in charge, then who's going to go to the bank to try to get the deposit box open? That's the big question. I like where if you're 83 years old and you still have your trust and you haven't provided a copy to whoever your trustee is, then I think you should do that right away. That's what I'm advising my clients. If you have a successor trustee and you think that the person is really trustworthy and that's who you want to have, forever, then give them a copy of that trust. You keep the original yourself and just keep it from getting burned up. So those are all really good questions. You're listening to The Word on Wealth, where we talk about building, protecting, and transferring your wealth. And the transfer part is going to be the estate planning. That's the stuff we've been talking about specifically today. We're going to be talking about more of this as we go on through the week. If you have questions for me regarding your estate plan, if you want a free estate plan review, I will look at your trust. Not if it's the last year or two, because there's not going to be anything new to change. But if you got it done by somebody, you're not sure whether it's right, or you don't trust what they did, or you did it yourself, or your brother did it for you, or whatever, we can take a look at it and make sure that it's done right. The number is 855-500-TRUST, 855-500-TRUST. If you got a trust that's been sitting around, it's been 5 or 8 or 10 years, it's probably time to take a look at it and see if everything is still good with what you want with that. 855-500-TRUST is my number. What we're going to have coming up next is we have Rich Mathurin from GQ Law. We're going to switch our topic to tax problem solving with GQ Law coming up next here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com. Team. That's GQlaw.com. 855-500-TRUST.
Go ahead.
Hey, welcome to The Word on Wealth. This is Gary Quackenbush, and today it's our Monday, so this is where we do our tax problem solving day. So we got Rich along with us. Hey, Rich, how you doing?
Great, Gary.
All right. So usually Rich and I sit down for a couple minutes on Monday and say, what's new besides the government shutting down?
Let's hope not.
I know. It's one of those things where, I mean, years ago, they actually did shut down. I have this great recording. I called the IRS. And I think I have it in my drawer in the office, but it was like, it literally was, you called the IRS and it says, the Internal Revenue Service is closed due to the, failure, the government balance, the failure to provide a balanced budget. Check your local news sources for the reopening of the U.S. government, and it would hang up. And it was funny. I recorded it because I thought it was so funny. I know you could shut a government down, but apparently you can. You just have to disagree on money. So, but lately we've been throwing so many trillions of dollars out there. I don't know. I'm sure they're going to come up with something somewhere. Who knows? Gee whiz. So Rich is a tax attorney here with GQ Law. And to get a hold of him, to get an appointment directly with him for a review of your tax situation, or if you have any questions, you can call Rich directly. And we're using our studio line, that's 855-500-TRUST, to talk about any tax situations. Mostly these are tax controversy things where, just there's a lot of stuff. So Rich, first of all, what I'd like to talk about is what kind of problems do you see with taxes? I mean, why do people, because we're going to talk about people that owe a lot of money. And for some people that's 30,000, and some people we know it's multi-millions. But what do you see as being things that cause people to have these huge, big tax liabilities that we deal with?
I think a lot of them have their own personal businesses and don't take out the appropriate tax every pay period or every month. And then at the end of the year, they don't realize how much money they've made and they get a huge tax bill. Some of them have personal problems, medical or family problems that cause them to not be able to pay their tax. Various reasons, like in life, I think,
stuff happens.
Stuff happens. Exactly.
So if somebody gets, they put their tax return together, maybe it's their first year being self-employed, and then they have this big tax balance. They just panic. They file the return. They try to run away. What happens?
Some cases they do file. We have a lot of clients that don't file their returns for some reason. We always encourage our clients to file their taxes, even if you can't pay the balance at the time, because there are programs that, whether it's an installment agreement to pay your balance going forward, or offering compromise, or possibly non-collectible status, maybe even a bankruptcy, a lot of different avenues to deal with it. But burying your head in the sand, that's the worst thing you can do, because they will come and find you eventually.
Yeah, it's not like your head's in the sand, so they're going to stop charging you penalties. That doesn't work that way. So let's talk about offers and compromise, because you've been doing a lot of those lately, and it seems like, in fact, we even talked about it in our staff meeting this morning, that it's like, hey, Rich, you got another notice of acceptance of offer. Let's talk about what an offer is. And then I want to talk specifically about if you do put together an offer, is it conditional? Is it like 100%? Or are there certain things you have to do to kind of maintain this IRS accepted less tax status? So talk to us a little bit about, what is this offer in compromise? What does that mean, we're doing an offer in compromise?
An offer in compromise is a specific program of the IRS. I think one thing people get confused by ads or whatever on radio or TV is that they just have some money available and they can just offer to the IRS for their total balance. And there's some guy in the back room with a cigar that gives the thumbs up or the thumbs down. It's really a program. It is a two-step qualification. One, you can't be able to pay your balance in full through an installment agreement. So if you have net income that would pay your balance in full over some number of months, then they want to push you into that full payment installment agreement. Second, if you have assets, equity and assets like home equity, retirement equity, bank account equity, sometimes vehicle equity, and that amounts are equal or close to the balance that you owe, they want to be paid in full through the equity in those assets, or whether borrow against them or sell them or whatever. So if you have like a home equity, you're not an offer in compromise candidate.
And I mean, that's the thing that makes sense. And I've always been, fascinated. To me, it's always kind of fascinated me that, you could hear this advertisement on TV that says, pennies on a dollar. And then they have some testimony saying, I owed the IRS, $46,000 and this company got me off, for $150. And then we'll have people that will call us that would say, well, I already talked to so-and-so tax resolution. And they told me that they could resolve my whole case for $10,000. And then when you talk to them, it's like, well, do you own a home? Yes. And how much equity do you have? Oh, probably less than 200,000. How much do you owe in taxes? $75,000. Well, you're probably not going to qualify for an offer. And how many times did people go, well, that's what I thought?
Yeah.
You know,
we had a client recently that somebody told him that he didn't have to include the equity in his home. And then the IRS came back
Wow.
and said, okay, we'll accept your offer, but we want $1 million or something. So it was like,
Yeah.
you know,
That's
great.
true.
Thanks.
Well,
for that.
that's pennies on a dollar, right? There are 100 pennies in every dollar.
I don't think he even owed $1 million. So it was like they you know, that was their counter to his proposal. So again,
Interesting.
you make sure that
Yeah.
whoever you're talking to looks at your financial situation, both your assets and your income. If your income is significant enough that you have the ability to pay your balance off under a installment agreement, they're going to push you into that. Or if you have that equity in the assets, that's the retirement, that's the home equity, bank balances, so that they're going to want pretty much a full pay offer. So it may, you know, you probably want to consider other options in those two cases.
Okay, so let's talk about an offer like somebody does qualify. They don't have equity, or they have minimal equity and assets. They're with their budget, it's just really tight. There's no real disposable income at the end of the month, and they agree to an offer. So we'll just use numbers and say they owed $100,000 to the government. The government agreed to accept $10,000, and they pay the $10,000. Does the government just go away forever at that point? Do they continue to monitor the case? Tell us about when people are agreeing to pay that money on the offer and compromise, what's the agreement they're really making with the IRS?
Well, I think we talked about this in the past. It's both wanting to take care of your previous tax balance, but they also want to ensure that you're in compliance going forward. So right now, I think the policy is that you have to be in tax compliance for 5 years after acceptance, 5 years after that. That means you have to have all returns filed and balances paid on time. You can't, file and not pay or not file. What happens then is they will rescind your acceptance and put you back into collections and have your balance owing again. So, that's very, very important that you stay in compliance for 5 years going forward. I did hear recently that they may be amending that to, I think I heard from a offer specialist that it may change to 3 years, but I have to confirm that. But
Funny.
I did get that it may be changing from 5 to 3 years, but I have to confirm that with some research.
But the idea is that a lot of people just think, okay, I'm just going to pay my offer and compromise. I'm going to get the money from my grandma or whatever, and I pay it, and then they go back and they've now kind of caught up, if you will, because they paid their offer, and then they just think, going on into the future, I'll just do another one later. But then within that 3 to 5 year period, they fall behind, they owe taxes again, they don't make their estimated tax payments. So what you're saying is the IRS, their agreement is, okay, we've determined how much you could afford and how much the offer would be, which is all negotiated, which is what you do. And then that money gets paid. Then the agreement with the IRS is, okay, we've accepted your payment. We're wiping out your other balances so that you're like zeroed out, but you agree to obey the tax laws for the next 3 to 5 years. And if you don't, they just go back and they almost pretend like there was no offer, right? They just, here's your tax liability, penalties and interest.
Call it a rescindance, and you're back in collections, and you have the balance owing that you had prior to the offer acceptance. So it's a big thing with them. And when you sign the forms agreeing to the acceptance, you have to, that's part of the deal, that you have to agree to be in compliance for 5 years going forward.
And that seems fair to me. That seems fair. It's like, if the IRS is canceling a lot of liability, and we have seen, you guys, we have seen some big old numbers with the IRS. I mean, we literally, Richard did an offer recently where the liability was close to $7 million. And we got this incredible offer. The IRS, the client was barely able to afford it. And we just have to watch for the next 5 years and make sure he's still, doing his thing and being in compliance. But you can get good deals with the offer. So when we come back, we're still talking to Rich Mathurin from GQ Law about, offers and some other things to get rid of tax problems here on The Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Well with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST.
So, Gary, we've talked a long time about estate administration. So, what is that, and why is it important?
Estate administration is the distribution part of estate planning. So when someone passes away and they leave money to beneficiaries, the property has to be administered. So it's like taking it from the decedent to the survivor. That's called the estate administration process. So usually you're going to have a successor trustee that's named in the trust. So have no idea what they're doing because they've never done it before. So then they call on GQ Law and we walk them step by step on how to be a successful and good successor trustee. We also do the required notifications. We notify the Department of Health Services and all the legal requirements so that they can have the estate administration done properly. We help successor trustees be successful.
Call or click to request your free consultation. gqlaw.com, 855-500-TRUST, gqlaw.com.
Friend about this broadcast outreach, The Word on Well, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, gqlaw.com.
You're live.
Hey, everybody. Welcome to Word on Well. This is Gary Quackenbush and Rich Mathurin of GQ Law. We got Rich. We're always privileged to have Rich on Mondays. He's super busy solving people's tax problems and dealing with, man, you do a lot more than tax problems. But so today we're talking about offers and compromise. And, Rich is really good at this stuff. And so I want to turn the mic over to him to talk about the offer and compromise, the good that this program is able to do.
Yeah, we talked about, some of the pitfalls or whatever, but this is an incredible program if you qualify. I wanted to mention three things that are really different about an offer versus maybe a bankruptcy or an installment agreement. First of all, if you didn't file your own returns and you have substitute returns that the IRS filed in place for you, or you had 940 the unemployment taxes from your business that were assessed to you personally, they call those the trust fund recovery penalties. Those would not be dischargeable in a bankruptcy, but they are something that included in an offer. So you can get those those trust fund recovery penalty amounts included in the offer. You can get these any years that were substitute returns. Those can be included in an offer. Second thing is that
So basically it's like anything you owe to the IRS can be included in this offer.
yes,
Yeah, because some of those things are really tricky. Like we do the bankruptcy and you can get rid of like the 1040s, and sometimes that's just fantastic. But then you've got this leftover, especially what I'm hearing about a lot of this is that a lot of tax problems come from like small business and payroll problems and all that. And those aren't as easy to get rid. In fact, you can't get rid of a lot of that in a bankruptcy, but yet in an offer you could.
yeah, I've discharged a lot of trust fund recovery penalties, the 940, 941
Yeah,
small
that's
business
great.
payroll taxes. Another thing that is very good is when you get an acceptance that they would have released any liens that they have against you. In a bankruptcy, that's not
Oh, that's
necessarily
right.
the case. You might get discharged from personally owing on the taxes in a bankruptcy, but the IRS and the franchise tax board don't necessarily have to release their liens. But here, if you have an acceptance from the IRS for an offer, they do release their liens. And then the third point that I would make is people always complain to me about interest and penalties, that the interest and
right.
penalties is as much as the tax assessment.
I know. Right?
Those are, it's your entire tax balance for a year, including interest and penalties that are included in the offer. So you can wipe out, like you said, we've wiped out hundreds of thousands for 10 cents on the dollar. But again, make sure that you do qualify. If you have enough income where you can pay your balance on an installment agreement, or you have those assets, equity and assets, you're probably not an offer candidate. But otherwise, it's an incredible program to use.
And haven't we also found out that, sometimes initially somebody just doesn't qualify for an offer because their income is too high, because the IRS looks back, what is it, 6 months or 12 months of income?
I think generally 6 months. That's kind of a thing that I'm always arguing. What's the point? Are they taking the current information? Are they taking when you filed? Are
Right.
they taking 6 months, 9 months, a year? That's always that's where I feel like I really earn my money working with these offer specialists to kind of get it the best point of view for the client as to when their income was maybe the lowest,
Right.
and their assets value was the lowest type of thing, versus taking it at the highest point that maybe the IRS would probably prefer.
Interesting. No, and I think that's that's why, don't do these offers yourself. They sound like, oh, that's, we can do an offer and compromise. But gosh, one of the challenges is if you submit an offer and you screw it all up, and that's probably not a legal term, but you mess up the offer, you don't do it right. You submit documents, you disclose a bunch of information, whatever. And then the IRS rejects the offer. Like, sorry, you can full pay. If you then try to turn around immediately and you now submit an offer with different information, they look at it like, well, wait a minute, you signed this offer under the penalty of perjury saying this is all true and correct. And now here's a new one 3 months later, and the information has changed. And now it looks like you qualify for an offer. Were you lying then or are you lying now? So the thing with the IRS is they keep records for a long time. They're like elephants. They remember things because they have it all recorded, and all their records and stuff. But with these offers, it seems like, when you get them through, they may look at an offer like what Rich would do. I think this is what we're doing, right, Rich, is that you'll look at somebody's income and go, well, your income, your income dropped like 6 months ago. We're probably going to have to include your older income in there. So let's wait a few months. Let's get it so that your income average is better. Or if a client comes in and they like, I got to do an offer and compromise. I'm unemployed. I can't even afford food. It's like, well, you can't do an offer when you're unemployed because the IRS wants to see that you have some stability in income. So if they're saying, well, then I'm going to, if I work really hard at this in the next 18 months, I can get a job that's making $500,000 a year. I think you would say, well, then just get a regular job now, because you're going to qualify for an offer. Just stabilize your income, stabilize your life, quit trying to be so, flamboyant out there and make all this money. You got to get this tax problem under control. And I think we've seen that quite a bit, where it's like, why are you working overtime and day and night, morning and night, to try to get this, your income up? It's making it harder to do an offer. Just relax, budget more. Now, sometimes we've had to do like a bankruptcy to get rid of their like debt and stuff like that so that you can then manage an offer, right?
Yeah, I have had a couple of clients that had done a bankruptcy previously, and then we do an offer for them and to wipe out, give them some positive income on their monthly
Mhm.
budget, because a lot of it was going to credit card payments or medical bills. So yeah. Uh, and one other a good point, a feature of an offer that I will mention, I think people think of, well, you have to pay immediately over to the IRS, whatever you offer if you have an acceptance. What happens is you let's say you offer 10,000 for $100,000 balance, just as an example.
Yeah.
20% would have to be paid with the offer, so 2,000 would have to be paid with the offer. And then once the offer is accepted, the remaining 8,000 would have to be paid over 5 months. So you're probably looking, from the time the offer is submitted till the acceptance, about a year and a half. So it isn't, you have to pay the amounts
That's a
immediately.
good point.
Also, if you're a low income person, I think it's like 43,000. If you make for an individual or less, they will waive the 20% down payment. So if you're a low income individual, you might even be able to forego that 20% down payment.
So then you would submit. So if you're under in the low income number, and so you don't have to submit the 20% with the offer. It's just like, okay, if the offer is accepted, then you have to pay it out in the 5 months.
5 months. Yeah, exactly.
Interesting.
So we make sure to monitor the client's income. And I have had a couple of clients that did qualify for the low income, and I think they waived the application fee too. I think it's like a $205 application fee. So if you're low income, but like Gary said, make sure, have some income, Social Security, a job, your own business, whatever. You do need to show some income, because they're not gonna, if you're selling pencils on the side of the street, they probably will not accept your your offer, because
I've
you
been
don't
doing it for months.
So
Offer, then it's like this works with basically, we're talking about IRS offer and compromise. And the deal is we're going to the IRS with an offer. The offer has to meet certain criteria, and if they accept the offer, they are compromising or reducing the amount that's owed.
Mhm.
And you're saying that this could be for payroll taxes. It could be for like the spillover from a corporate liability. It might be a trust fund recovery penalty tax, personal income tax. Gosh, I guess it could be any type of federal.
Remember we talked about in the bankruptcy discussion, the substitute returns, where
that's right.
Even if you replace a substitute return later on, those are not dischargeable in bankruptcy. So that's a real, that's something you have to consider with the bankruptcy versus the offer. It's a good, really good program, but you do need to do it well. I always say with the offer application, pigs get fat, hogs get slaughtered. So take everything you can, but don't, they have their standards that they're going to allow for expenses. They're going to value your assets in a certain way. They're going to allow you exemptions and things like that. Make sure you take everything you're allowed and entitled to, but, don't try to hide assets or try to, fake things, but because they will catch you. Like you said, they have a way of knowing pretty much anything that goes on.
Yeah. And it sticks with you, I'll tell you. So that's interesting that I've really enjoyed being able to, work with you with the offer and compromise program, and to see what we're able to get. And, sometimes it's a matter of patience too. I know, people, you would believe, the way there's a lot of advertisement, like you come in and if you offer the IRS any amount of money, they're going to be so happy, they're just going to go away. But the reality is with the offer, there's a lot of patience involved. The application, you submit it, and even though you submit it quickly, they take a while to process. And sometimes you have to submit documents over and over to get it. And it's just a process. It's more like what we're trying to work as a long-term solution, so that this is something where you won't owe again. You're not going to have to deal with the tax problem again. It's just going to be taken care of. So sometimes it requires some patience.
Yeah, it definitely, but it's life changing. Like I've had, I can think of 10 clients right off the top of my head that, we got really huge discounts for, and they were able to move on with their lives. Another thing that I will mention on the offer is, once it's submitted, all involuntary collection activities stop. So the IRS isn't going to levy your bank accounts, garnish your wages, or anything like that while the offer is processed. So it is a time, there is some time delay from the application to when they have a decision, but you're not in collections during that time. So that's a relief too.
That might be something interesting. So if you want help with this, call Rich at 855-500-TRUST, 855-500-TRUST, and we can help you out, figure out your tax situation. Do you qualify for an offer and compromise? Do you need to get back tax returns filed? Do you have other debts that need to be dealt with? We're dealing with all kinds of things like that. Sometimes we're setting up a small business corporation or a limited liability company to help manage your business finances to get you set up so that you can then be on kind of the straight and narrow tax path, getting all the tax compliances, and then do an offer and compromise. So there's a lot to do, but we're trying to get it back on track so that you, your cousin, your friend, your neighbor, whoever's got the tax situation, we get you back on track so that you can sleep at night, not be so worried about, when's the IRS going to come and shut you down. Give us a call, 855-500-TRUST. Hey guys, we'll be back tomorrow, same time, same station here on the Word on Wealth. Talk more about estate planning and trusts here on the Word on Wealth.
Tell a friend about the Word on Wealth, featured since 1995 with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help you preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual